Dalzell.
Believe that the House is entitled to an answer to the question that I posed earlier on, and actually one that's described by the Chief Judge of the Youth Court as constituting the most fundamental change to the system since its inception in 1989. And that's why I think that we are entitled to an explicit answer around the age. Why is the age of criminal responsibility for offences, in addition to manslaughter and murder, which are already covered? I do keep re-emphasising that, because the examples that we're often given out there in the public arena are those examples that are already covered by that extension by way of exception. This makes it more of the rule rather than the exception. And I want to know what the evidence is that the government is using to lower that age. And what I mean by evidence is, what evidence does the government have that shows that changing the age and shifting the jurisdiction to the youth court will in fact make a difference in terms of turning around the lives of children? And I want to know why the Minister can't say children. These are children under her own Act. Under the Children, Young Persons and Their Families Act, you are a child until you are 14, and then you are a young person. So it's unfortunate that she won't pick up on the language, because I've got a very important other question for her. Just over a week ago, we referred another bill to the Select Committee. It wasn't a bill in the Minister's name, but in the name of the Minister of Justice, and that was to make an amendment to the offence provisions of the Adoption Act so that the government could ratify the optional protocol to UNCROC. Well, how on earth does this stack up with the United Nations Convention on the Rights of Children and our responsibilities, obligations as a country to that convention to which we are a party? My understanding is that the government actually failed to even mention that this bill was in front of the House when it appeared in front of the UN's Human Rights Council last year. And that suggests to me that this bill actually runs directly counter to our UNCROC obligations, and I think that the Minister should get up and explain whether that is the case, and if it is the case, why on earth we would want to go down one track with the Minister of Justice and his changes to the Adoption Act, and another track with this Minister in order to really counter our obligations under that piece of legislation. Or that particular convention. The evidence base for me is the issue, and I don't think the Minister was around at the time I was quoting from the very excellent appointment that the government made to the Department of Prime Minister and Cabinet, one Professor Gluckman. I was actually relieved when the Prime Minister appointed him to such an important position, because what the Prime Minister was saying by way of that appointment was that in fact he was saying that it was important to have an evidence base wrapped around social policy decisions, as you would do in all other elements of economic and scientific endeavour. And I just want to quote from the report. Point of order, Mr. Speaker.
Point of order, Leanne Dalzell.
Point of order, Mr. Speaker. I understand that if the Minister is in the House, the Minister has to be in the chair. The Minister is having a conversation with one of the members there in the back of the House, and I don't think she understands the standing orders in that regard.
The member is quite right. Could I just say to the Minister, the Honourable Paula Bennett, that if you are in the chamber, you are required to be in the chair. While we're organising here, we've had a slight accident. As I was reorganised, the Minister either will resume the chair or will leave the chamber. She's leaving the chamber. I call on the Honourable Leanne Dalzell.
Mr. Chairman, well, I think it's unfortunate that the Minister in the chair has had a wee accident, but
It's all right, we won't tell anybody.
I couldn't resist that. I couldn't.
Won't tell anybody. National television.
Very good. I was going to quote Professor Gluckman. I wanted to do it for the benefit of the Honourable Paula Bennett, but unfortunately I'm not able to do that, so I'll have to find another occasion for that. But it is actually very important, because what Professor Gluckman was saying was he was talking about the need for evidence to be rigorously based and inform policy formation. And then he goes on to say, and this I thought was really relevant, that there were many cogent reasons why evidence and policy need not align. The evidence may not be complete, well, that's a reasonable reason why they may not align. The public may not accept the evidence. Well, that's a challenge then, because you've really got to explain things to the public. And it may conflict with the accepted values of a society, and that's certainly an issue around some of the harm reduction approaches that one would like to take. And on that note, I'd just like to say that I was very disappointed in the Minister of Justice's immediate knee-jerk response to the Misuse of Drugs Act report from the Law Commission. The cost implications may be contrary to the approach. Mr Chairman?
I call Jacinda Ardern.
Thank you, Mr Chair.